Patent application sin number 4 is obviousness, which is just an expected variation. Committing this sin creates the horror of failing the person of ordinary skill test. Even if your invention is new or novel, you may not obtain a patent if it's deemed obvious. And here's the test. The invention must not be an obvious extension or modification of existing work in the eyes of a person having ordinary skill in the relevant field. Here's the trap. What seems like a brilliant leap to you, if you aren't someone who works in the field of the invention regularly, may be considered an obvious combination of existing solutions to someone who does. Here's the danger: rejection. If the differences between your invention and the prior art are such that the subject matter as a whole would have been obvious at the time the invention was made, the application will be rejected. But here's actionable takeaway to prevent committing the patent application sin of obviousness. When drafting claims, emphasize the unexpected result or the technical difficulty that your invention overcame. To try to avoid a rejection for obviousness or argue against one, your lawyer must argue that your invention represents a significant leap beyond what has been previously achieved for good reason. Intellectual property is one of the most terrifyingly useful tools you have. If you're ready to build a frighteningly powerful business and brand, you don't have to face the darkness alone. Book your consultation with me at kingpatentlaw.com. I serve entrepreneurs across the U.S. You can find all my other frighteningly good content on the King Patent Law website and at King Patent Law on social media. Finally, this information is for educational purposes only, isn't legal advice, and doesn't form an attorney-client relationship. Always seek the counsel of an experienced licensed attorney, perhaps me, for your specific legal needs. Avoid the legal horrors and keep rocking your IP.